Hello, and thank you for joining us for today's virtual education program at Cancer Support Community South Bay. I'm Rebecca, the program manager, and I welcome you to this workshop titled Getting Your Affairs in Order. Before we begin, if this is your first time joining us, CSC South Bay's mission is to uplift and strengthen people impacted by cancer by providing support, fostering compassionate communities, and breaking down barriers to care. Our vision is that everyone impacted by cancer receives the support they want and need throughout the experience. We serve the South Bay, Long Beach, and Orange County area all at no cost. Our program includes support groups, networking groups, healthy lifestyle classes, social activities, and educational programs like this workshop. Educational programs are open to all. If you'd like to hear more about our services or join a community, please visit our website at cscsouthbay.org. Before I introduce today's speaker, we ask you to keep your microphone muted to eliminate any distracting background noise. Please feel free to enter any general questions into the chat function found at the bottom of the Zoom window at any time. Anna will not be able to provide any legal advice on specific circumstances, but she'll be able to answer any general questions at the end of her presentation. Without further ado, I'll introduce our workshop speaker. Anna Schneider is a well-known attorney in the South Bay and volunteers her time as a member of the Professional Advisory Council at Cancer Support Community South Bay. Anna, an expert in estate planning, will present ideas to protect your assets and ensure that your loved ones are taken care of and avoid probate. Thank you, Anna, for being here with us today.
Hi, thank you, everybody. Thanks for coming. I appreciate it. I've been working for the Cancer Support community for many years now, I think going on 7 years, and I appreciate that they always ask me back. So what I like to do is just present an overview of what is an estate plan and does it make sense for you, and how is it that it helps you to get your affairs in order. So that's basically what I'm going to cover today. And as Rebecca said, I'm fine with answering questions at the end. Either put them in the chat or, of course, I can give you my contact information, and later on you could contact me, and I'd be happy to, talk with people on the phone and see if I can offer any more assistance at that time. Okay, so let's get started. When we set up an estate plan, what is it that we're really concerned about? And the topics that most people are concerned about are listed here, the following. Number one, who's going to make decisions for me if I can't make my own decisions? And these are broken down into two categories: healthcare decisions and financial decisions. So when I meet with clients, this is one of the biggest topics we tackle, because you want someone that you can trust that's going to make decisions in your best interest when you're unable to advocate for yourself. And secondly, we talk about the estate plan in terms of assets. If you don't have an estate plan, then you have to worry about who's going to get your assets, who's going to oversee everything. With your estate plan, when you make your own wishes known by creating the estate plan, which would be a will, a living trust, you get control over these decisions. If you don't put these down in a living trust or will, then California does have a plan, and it's called probate. And probate is a court supervised lawsuit, like case, not quite lawsuit, but case, where you're going to go through the court system and they have a list, a hierarchy of who will inherit your assets. And in Los Angeles County, that's taking almost about 2 years to go through. Orange County is actually moving a little bit slower. And then, the other areas I practice in would be Riverside, San Bernardino. All of these are very backed up, and there's a shortage of judges. So even without any kind of fighting it's taking quite a bit of time. And also the biggest concern is the amount of money it's going to cost the family. So these are basically decisions that you would like to make while you can, put them down in writing, and basically you get to protect yourself and you get to protect your loved ones, your family. Okay, so how do we do that? What are the documents? When people talk about estate planning, it usually refers to four main documents. Number one would be a revocable trust or living trust. Those are basically interchangeable terms. Next is a will. And these two documents are really to transfer your property to your family after you've passed away and to have that done according to your wishes. And as I was talking just earlier, the other documents, the power of attorney for finances and an advanced healthcare directive. Those are documents that are used while you're alive and you can't advocate for yourself. So all four of these documents are basically the foundation of what we call an estate plan. Now, certainly you can just go and have any one of these done according to your needs. Not everybody may need these. Sometimes people have advanced healthcare directives done when they go to their doctor. Maybe they've gone to the hospital. Maybe they've already filled out a power of attorney at their bank. So you would have to see whether or not when you go see your attorney, do I really need these? But these are all the things that you should at least be talking with an attorney about. And when it comes to a trust or will, it's going to be very specific as to whether or not you need a trust or a will. Mostly when you need a trust, you will definitely also need a will. But the reverse is not necessarily the case. You may be able to just suffice with a will and not need a living trust. But that's going to be really dependent on your specific scenario, your situation, your family situation, the type of property you own. And so those are also things that you're going to basically get into and talk with an attorney about. So these are kind of the typical issues I see when my clients come in. And I know a lot of people think most of my clients are older, maybe seniors and up. But you'd be surprised how many of my clients are actually in their early 30s, 40s as well. And they come and I believe they've seen the effect from their parents and grandparents when they didn't have these documents. So most of my couples, when they come in, most couples will in fact want to do all four of these documents. And it makes sense for them, especially if they own a home or a property, a condo. Let's say they know that they're going to have some, issues down the road. They want to get these all put into place now. And then alongside these, we also will talk about if they have minor children and, life insurance, as well as other bank accounts. All of these things are dealt with. But typically in your 20s and 50 through your 50s, these are the things that most people are looking at and they want to have done. So then now let's look a little bit forward. When you're in your 60s and upwards. At that point, sometimes things actually are simplified. And the reason is maybe in your 60s, you've had children that are now adults. So you know your kid's personality, and maybe you've seen that they are responsible. Maybe you've seen they're not. But usually you've kind of seen that you know the choices that you're going to make. That yes, I can pick my son or daughter to be involved in my estate plan. And you start talking to your adult children about this. Sometimes you've already had an estate plan And you've decided that for each of these documents that we've talked about, you designate agents to act for you. So perhaps when you did these documents in your 30s, 40s, your children were minors. And or maybe you were picking best friends, siblings, parents to be these agents. But now that you're in your 60s, you look and you say, you know, my kids can handle these decisions. They've earned the responsibility. There's issues that can be, you know, noticed and then perhaps reevaluated. So now maybe instead of having your parents or a sibling be a successor trustee or an alternate trustee, now you'd like to have one of your children or many of your children or several. It can really just change as life goes on. Sometimes people choose friends that maybe have passed away, or they just don't have relationships with those people anymore. So this is where I see people come back, and if they do have something already put in place, we're making some changes because it just doesn't make sense where they are in their life now. And also at this time, we also look at what other needs they may have and what other professionals I may have to refer them to. So perhaps they need long-term care. Maybe they don't have financial planning in place, but they need a financial planner. I actually see this quite a bit when I have widows. They come in and they feel that they don't want to handle all of their finances anymore. Same with widowers. They don't want to handle it all by themselves. So they feel more comfortable having a team put in place. They have a trusted CPA, but maybe they don't have a financial planner, or maybe they don't have the CPA. So we tend to all work together really nicely as a team, and we all consult with each other. And while we do this, all the people in this team, what we do is we're also looking at, are there undue influence issues going on? In other words, are we hearing maybe a daughter or son is exerting some pressure on mom and dad to do certain things? Oh, leave me the house. Let me, you know, get a bigger chunk of the money. So we're always watching for these types of issues with our clients. You know, this kind of relationship becomes a very close, trusting one. People really open up to me about their families. And I've been an attorney for 32 years. And so many people think that they have atypical situations. But in fact, they usually are not in a situation that I've not heard before. So I do know a lot of different ways to handle situations and how to talk to people. And I don't make their decisions for them, but I certainly talk to them so they can, you know, we talk things out and they come to their own decisions. So yeah, these are the things that I'm seeing, and these are the issues that we see going forward. So when we set up your actual documents, your trust, your will, it doesn't just end with signing the documents. The next step is going to be making sure that you have the correct type of accounts put in the name of the trust, as well as you make sure that certain types of accounts are reviewed to make sure your beneficiaries are in fact the right beneficiaries. So for instance, what type of properties do you put in a trust? You would put real property, so that means your home, your condo. And normally the attorney, in fact, handles that for you. We prepare a new deed where we actually transfer the title into the name of this living trust that we've created for you. And then if you have savings accounts, we would advise that you go to your bank and you ask them to retitle those bank accounts into the name of the living trust. CDs, mutual funds, investment accounts, those are all additional accounts that need to be put into the name of the trust, which means going to your bank and having them change the name on it. So instead of Anna Schneider on my savings account, it's going to be the Schneider Family Trust on my savings account. And the reason you do that is if something happens to you, whoever you've chosen as your trustee, as the trustee, that person will be able to have control over those bank accounts and your house and property. And that's what you really want. Now, on the other hand, you don't change title on accounts that I've listed here, 401k, the 403b, IRAs, and annuities. And the reason is those are types of accounts that the law allows you to list a beneficiary. And listing a beneficiary is the way that whatever company is administering it. So let's say you have an account at Schwab and they're holding your IRA. You will tell them who you want as your beneficiary, and that's who they'll put on that IRA. So it never goes into the trust. Now, there are exceptions, and I'd be happy to talk about that, but that's really going to be dealing with if you have minor children, then we would deal with that in a different way. Now, life insurance also is handled where you just can name beneficiaries. So I always tell my clients to please review these and make sure that whoever is on these accounts as your beneficiaries are who you still want. Because sometimes people get divorced and they forget to take off an ex-spouse. Sometimes a spouse has predeceased and they forget that the spouse was the beneficiary. So that's why I always just have them look at these, try to review these every year. Next, another thing that goes on when people start getting into their 60s and later in life is maybe they find themselves that they have enough money and they're comfortable and they know that they're going to be fine financially. So they decide at this time, I can afford to give some gifts to my family so I can see them enjoy the money now. So sometimes these clients, what they'll do is they'll gift money to their children, their son or daughter-in-laws, the grandchildren, their brothers and sisters. Also charities. They start gifting, making bigger gifts to charities. So during your time that you are evaluating who you're going to give your property to when you're creating this trust, you do want to think about, besides your family, maybe I'd like to give a little gift to somebody. Sometimes people leave a gift to a charity that has meant something to them, maybe helped their family members. It could be their college. Maybe they're an animal lover. Maybe they were a vet of they'll do one of the disabled veterans, VFW, lots of different charities. So you want to consider adding these gifts at this time. Also, I also talk about giving special gifts such as maybe you have something sentimental that your family owns that you want to make sure gets passed down to your family, whether that is jewelry. It could be, I've seen people have war medals. I mean, I've had so many different, I've had people who are musicians and they know that they have friends who are musicians that would really appreciate having those instruments. I've had people want to leave handguns to their friends who are also into that, maybe a motorcycle. So the list of that goes on. And it doesn't have to be something that's an extremely valuable item. It can simply be something sentimental. So these are things that you want to think about and talk to your attorney about and make sure they're setting up when you're doing your estate plan, because this is the time to get it done. And maybe you already have an estate plan. You certainly can go back as long as you're mentally able to still make your decisions. You can always amend your estate plan, what you have in place. Okay. Okay, so let's say you have the estate plan. Now we go into what we say maintenance, and it's basically what I was already talking about. You just always want to look at these documents every 1 to 2 years, making sure everything you own is in the right place. Because if you don't have these items, like the property, in the right name or title, then it can be a little tricky later on for when you're going to be, your family may be dealing with these issues. Okay. So definitely look at, excuse me, definitely you can talk with your attorneys about the assets. And just as I was saying, titling it, or whether we need a beneficiary designation of some sort. Trust funding, you may hear that word. Basically, trust funding is just the term that we use to say we have to put the asset, the property or bank account, in the name of the trust. So it's like when you go open up a bank account, let's say at Chase Bank, they make you put in a minimum amount of money. The same is going to happen with the trust. With the trust, you create the trust, but you need to put something in the name of the trust. So that's where putting a house and bank account completes the trust funding. Okay. Communication. Communication is really key. What you want to do is you want to make sure you have a dialogue with your agents, and you want to make sure that you are keeping everybody apprised of your wishes. So I think what you want to do is always have meetings with your family members to discuss what's going on. Try to be open. Try to let them know who are your financial planners, your CPAs, your attorneys. Give them the business cards, give them the, address, give them phone numbers, just as much information. It'll make it so much easier for them to contact these people if they need them later on. And then once again, just keep in contact yourself with these people. And we always watch for things such as elder abuse. That has been on the rise, especially when we have a situation where there's a caregiver and the caregiver is alone with the person a lot and they don't see family members around too much. There has been a big rise in elder abuse for financial elder abuse. I had a client just a few months ago where she had her caregiver who was with her like 5 days a week, and the daughter would come and check in on mom because she lived in another state. So the daughter would fly in every few, like 6-7 weeks, and she found out that the caregiver was getting a lot of extra money from the mother. And it became a real problem because it became thousands of dollars. So you really want to be careful that you keep a nice community, you have your friends, your advisors, and you're not isolating, or even for other family members, that they are not becoming isolated, because you definitely become susceptible to that type of, being preyed upon by somebody. Okay. It could be a neighbor who sees you're alone. So you want to think about that. Okay, so that is just the end of my presentation. As I said, it's to give you an overview of estate planning, kind of familiarize yourself with these words, these terms that you may hear, and just know that it's not just a living trust. There are more important documents, advanced healthcare directive, power of attorney, so very important. And I can't tell you how many times I've had clients, their children come back to me and say, I'm so glad my mom and dad had this, because when we needed it, it was already done. And it made things easier for me to take care of them. Because if something happened that somebody actually developed dementia, it's too late at that point for that person to actually execute these documents. You have to do them before the dementia sets in. And we attorneys are looking for that. And there is certain criteria that we're looking for. And if we're not sure, we're not going to go forward. And we would ask that maybe they're evaluated by a doctor. And that doctor would have to say that, yes, this client, this patient can execute these documents. Or sometimes they say the opposite. No, I'm sorry, I believe this person doesn't have the ability to make their own decisions. So you want to get these all done while you can. So that's why I advocate, do these things when you can, and when you have your thoughts clear. And I don't think it's that difficult to put these together. It doesn't take months and months and months. It's certainly, I feel that it's probably about the same as getting information together for tax return, or maybe a little bit easier, to be honest. So all I know is when my clients leave, they tell me over and over how relieved they are that they did this, and they feel really good that they've done this. So that is my presentation. I don't want to go into too much more detail. I don't want to, lose the audience here, but I'm happy to answer some general questions.
Thank you, Anna. So I do have a few. So for everyone else, please feel free to type them into the chat function. And as a reminder to keep them general, as Anna's not able to provide any legal advice on specific circumstances. But if you have general questions, absolutely. So the first one is, if you have a will, can you avoid probate?
If you have a will, can you avoid probate? It's going to depend on what property you have. Most likely, the answer is no. If
Okay.
you have just a will and you own a house, you will not avoid probate. You will go to probate.
So if you have a will but don't own a house, or then it wouldn't.
Well, then it depends. If you have a certain amount of assets over so in California, if you have assets that total over, I believe the threshold right now is $186,000 in a bank account, and that bank account has no beneficiary, but you have a will, if it's over that amount, you will not avoid a probate. If it's under that $186,000, you will avoid the probate. So it gets really tricky. It's like, if this, yes, if this, no. So it's very specific about what type of property it is and how much it's worth.
Got it. Thank you. The next one is there any catch or downside in California TOD deed?
The problem with those, this is the problem with those deeds. With those deeds, you put somebody's name on it, and the problem is, what if they pass away before you do?
And then can you
So
share what a CATOD deed is? Sorry.
I'm sorry, it's hard to hear you. Can you say that
Can you
again?
share about what the deed is for those who don't know what that means?
It's called a transfer on death deed. And basically it's a deed that you write on in the deed, in the document. It has a place for you to insert a beneficiary, someone to inherit your home. And you can write in a person's name, but what I don't like about that is if that person dies before you do, now you're stuck. So in a trust, we always have provisions in case a person passes away, then it shall go to their children. In case that happens, then it goes over here. So it's a constant, it follows the property down so that somebody will inherit it.
Thank you. Next question. All of our accounts are in a trust. Do I still need to notify the bank to name a beneficiary?
No, if you have retitled your property into the name of your trust, then that's fine. The title on the title on the bank account is what the bank will use on how that gets distributed. So that controls over if there's a beneficiary.
Thank you.
So the bank, does that make sense? If the bank account's in the name of the trust, it goes into the trust, period.
Yes, thank you. Next question. I have a revocable living trust. I do not have my checking or savings under this name because I have a beneficiary listed on each of these accounts. Should I change it?
Yeah, so I always advocate for the checking account. If like most of my clients will not have a tremendous amount of money in a checking account. And a checking account for many people is used kind of like an in and out. Money goes in, money comes out, money goes in, money comes out. So basically what you want to do is I would leave the checking alone, but I would make sure and put a beneficiary on it. Now, for the savings account, I would always put that in the trust because, once again, what if your beneficiary predeceases you? So if you had listed somebody and then they died before you do, now that bank account has nowhere to go. Now we're stuck in a probate.
Just to clarify, Anna, so once you have a beneficiary and let's say they predecease you, you can't change the name to a new beneficiary?
No, you can, but if you forgot, let's say you forgot that they were your beneficiary.
Thank you. Next question. How do I document guardianship of my minor children?
Oh, okay. No, that was a good question. That provision goes in people's wills, not the trust. So who the nomination is for a guardian would go in a will. And we set up living trusts for minors in a specific way so that the money is held in trust for them until a specific age, and that age would be determined when they get the money, and you get to decide what age you feel comfortable about that.
Thank you. This is back to the TOD deed. Someone had
I'm sorry, go ahead again, sorry.
About the TOD deed. If this person has both adult children, are unmarried and no children, and they have a TOD on their pink slips, if like, what happens if the beneficiary dies first?
Well, that's the problem. Then it'd go, and if that isn't changed, then it will go in a probate.
Okay, but if
And
they
it
do up,
goes,
sorry, go ahead, Anna.
I would say it would go to a probate, I believe. And then at that point, it goes to the next of kin, according to the California probate laws.
But if they do notice that the beneficiary had deceased, then they can update that though, correct? To a new
I mean, I
beneficiary.
believe so. Yeah, then in that case, they do.
Oh, okay,
I'm always operating on the assumption that someone may not remember to do these things.
absolutely.
I'm always off, I operate on the, I want to make sure to button down everything so that these things don't slip through the cracks. That's how we operate, you know. Go
Uh,
ahead. I'm sorry, Rebecca, if you have another question.
yes. This one is, if you can clarify simply, is the difference between a living trust and a trust fund?
Wait, between a living trust and a trust fund?
Yeah, are they the same thing or is that different?
Oh, what I was talking is funding a trust.
Got it.
Okay, the trust is the document that we create that holds title to your property. Funding the trust is the act where you retitle the property into the name of the trust.
Got
Does
it.
that answer that question?
Yes, I believe so.
Okay.
Um, are there any other questions? Please feel free to direct message me and I can read them out loud or you can send it to everybody. Wonderful. All right. I just want to thank you, Anna, for taking your time to share about this really important matter. And thank everyone for joining us today.
Thank you.